rise. Court of Appeals, Division 1 is now in session.
Please be seated. We're here today in our case 1C ACV 17-0057, Conway versus Circle K. Each side will have 20 minutes to present their argument. Plaintiff, you may save time for rebuttal, but keeping track of the time is for you to do this. That's why we have a clock at the podium. We are recording the argument both in audio and video. You'll be able to see yourself on YouTube in 2 or 3 days. Because we're recording it, though, we appreciate it if you would identify yourself and your client when you begin your argument. We've conferenced the case, we've discussed it, we're familiar with the facts and the arguments. So when you begin your argument, just launch right in to what you think we need to know. Counsel, you may begin.
Thank you. Good morning, if it please the court. My name is Kenneth Ray. I'm the counsel for Michael Conway. Mr. Conway is present in the courtroom today. Judges, we wish to first thank you for an opportunity that has been afforded through Judge Brown in granting oral argument today. That was something that we didn't have the benefit of before the trial court, and applying the standards in Cullen and in Coleman that require, as I appreciate it, this court to review this matter de novo, this being a 12B6 motion to dismiss that was granted on the defense motion, granted with prejudice, awarded attorney's fees predicated upon contract, of which we strenuously argue is not a part of this case.
Buying a lottery ticket isn't a contract?
Not in a contract with, it's a contract with the Arizona Lottery, but it is not a contract with Circle K, is our position.
You exchanged money with Circle K for a good.
Yes.
Now, it's albeit a good that's issued by the Lottery Commission.
Correct.
How does that not form a contract between you and Circle K?
Well, first, if you examine Rule 12B6 and the requirements to examine the four corners of the complaint, you will note that there was no contract action alleged in this particular case. Therefore, it's our position that in following those standards set forth in Coleman and in Cullen versus it's Auto Owners Insurance Company, you look to those four corners. There was never an allegation made for a breach of contract.
Well, but counsel, even assuming that there is some kind of valid fraud, claim here the fraud arises out of a contractual relationship, whether it's with Circle K or with the lottery.
No, and I respectfully disagree, Your Honor. The only reason a contract came into existence here was by virtue of the state, or the defense rather, contending that this case arose out of contract. The complaint did not allege contract.
But Mr. Ray, don't the rules of the state lottery say that it creates a contract?
As between the lottery and the purchaser of the ticket.
So there is in fact an underlying contract.
With respect to tickets that are legitimately purchased by a person such in the position of Mr. Conway.
So the fraud arises, I mean, the fraudulent, or the tort of fraud arises out of the contractual relationship.
No, sir, it arises out of the circumstances in which the purchase of the ticket was flawed. The purchase of the ticket was flawed in the context that Mr. Conway requested a certain set of tickets under a certain game by a quick pick. He got $4 worth of those tickets that he requested, and then the fraud occurred when Circle K clerk decided to hand to him, without his express consent or permission, another ticket representing it to be that which it wasn't.
Was it a quick pick ticket?
It was not.
What was it?
It was a ticket that was issued the day before by specific numbers selected by some customer who apparently rejected the ticket, and which then created an obligation under the administrative rules for Circle K to either resell the ticket or to pay the cost of that ticket themselves. And
So-
then this,
I'm sorry, go ahead.
no, I'm sorry, I didn't mean to interrupt you.
I was going to say, so they had a ticket for the price paid, numbers picked by somebody else,
Yes, sir.
instead of a different ticket with random numbers that they weren't going to try and pick.
That's correct.
How do we get, and if I can kind of change gears here a bit and get away from the issue of what constitutes, if anything constitutes a contract, in terms of a tort, how do we get to damages? How do we get to damages based upon an assertion that there are a set of numbers? First off, does your client assert that his numbers actually hit? So if he'd been given the numbers he asked for, he would have won the lottery.
Of course not, Judge.
So if he wouldn't have won the lottery with his numbers,
But his numbers would have been a random selection of quick pick numbers selected by the Lottery Commission. He asked for quick pick. He didn't get quick pick.
do we know what do we know what numbers randomly came up that would have been his had they sold him a new ticket?
That would be an impossibility to calculate or to decipher, Judge.
So if we don't know that, we don't know how those numbers would have fared in regard to the overall winner of the lottery.
Well, if you don't know what those numbers are because the numbers were never drawn, what you have done is you have lost the chance at those correct numbers coming up
So
through the random selection of the Lottery Commission.
So if your damages are lost opportunity or lost chance,
Yes.
wouldn't that be then the damage be the 6 in 300 million opportunity? So your damages would be a fraction of a cent or a fraction of a dollar?
No, Judge, I respectfully disagree. The lost chance was the opportunity to have randomly selected numbers, as per his request, generated by the Lottery Commission.
But there is
And
an
then on-
actual value of that opportunity.
Well, the actual value of the opportunity is the opportunity to win the jackpot or some lesser amount with lesser numbers matching. You see.
But we don't know that those numbers would have won the jackpot or would have won a lesser amount. So aren't the damages so illusory here that they kind of defy calculation?
No, Judge, and that was explained, I think, in detail in the context of the University of Arizona Health Sciences Center case, which is cited in the reply brief. And under the heading of speculative damages, I addressed that. And in that case, they said the difficult problem in quantifying general damages should not have prevented courts from awarding such damages if, in fact, an injury had occurred. We contend that the injury did occur by virtue of the fact that he requested one thing, he got something else without first being asked for permission, as required under the rules, the administrative rules, to, if you want, Mr. Conway, do you want to purchase this ticket? They were tickets that was generated yesterday, and they contained specific numbers that were selected by this other customer yesterday. If he had been asked that, he would have had the opportunity to accept or reject it. If he had accepted those numbers, knowing that.
Well, didn't he have an opportunity? Because they handed him one ticket that had $4 on it.
Correct.
And then a separate ticket that has the 6 numbers selected on it.
Correct.
Why wouldn't he have known at some point, I didn't get my $10 ticket?
Well, again, Judge, and with all due respect, what we're doing is we're peering into the underlying facts and
Well, yeah,
burden
but
of
you
proof.
just asserted that he had no knowledge, which doesn't seem to be consistent with the facts that you allege, which is you got, instead of getting a $10 ticket, you got a $4 and a $6 ticket.
Well, our contention is he rightfully relied upon the representation of getting that which he had requested.
Did the prior ticket indicate that it had printed the day before? They have a date and a time, don't they, on them as to when it was printed?
It's not overly clear that it was, but ultimately in the materials that were submitted to the trial court, we obtained from the Arizona Lottery the printouts which demonstrated exactly when this particular ticket number was generated and how it was generated and the times that it was generated. It was generated the day before. I would like to point out to the court, in the context of this, a recent decision that came down in December, I believe, 26th of this year by the Court of Appeals. Yes, December 26th of 2017, issued by the Court of Appeals.
Counsel, have you submitted a notice of supplemental authority?
No, I have not, Judge.
And did you give counsel a copy of that?
Honest to God, I just came up with this last evening in preparation for this argument today. So no, I have not.
I was surprised anyone was here on December 26th.
If you're going to discuss it, I'd appreciate it if you submit a notice of supplemental authority.
Oh, I will certainly do that. And my apologies if the tardiness of this is impacting anyone in any negative way. But the point of it is that it was the case of Andrew Muscat, M-U-S-C-A-T, versus Creative Intervisions, LLC. And in that case, they discussed the subject of the wrongful conduct rule. And in the context of that case, they said that a plaintiff cannot bring a tort action in negligence if his action is based upon his own wrongful conduct. And in the context of this particular case, I'm suggesting to you that the defense of last clear chance or any other defense of that nature is barred by the underlying fraud that caused the creation of this ticket and the passing of that ticket to my client.
Counsel, I would like to go back to the other case, and I apologize if I'm repeating Judge Morris's question, but your client did, by buying a ticket, your client was not guaranteeing himself that he was going to win a jackpot.
No.
What he bought was an opportunity to win that.
That is correct, and that is what was
jackpot. But that doesn't mean that the damages are the jackpot. That ticket, that chance has a particular value, and that's all that. Even if there was fraud, that's all that your client would be entitled to, is the value of that opportunity.
And the question then becomes, what is the value of that opportunity? For example, there is a retired Superior Court judge in this county that purchased an opportunity to win the lottery. He won the lottery. There is a former Senate president, Andrew Biggs, who, in whatever mechanism it happens, and I can't speak to how it happens, but he made application for the Publishers Clearinghouse, and he won. So when you look to what is the value of that chance is the value of the potential to win.
But isn't the value even greater, the likelihood that you won't, by 255 million to 1 or something like that?
But Judge, that may well be the odds in the context of trying to establish to a jury what the damages are. What we are here on today is a 12B6 motion that says that the complaint fails to state a claim upon which relief can be granted. You assume all material allegations of the complaint are true and in the favor of the plaintiff, and you make the determination, does it state a cause of action? I respectfully submit this case does. And if the difficulty is in establishing damages, it is not for a jurist or a judge to pass upon that, because that's ruling upon merits that is solely within the province of a jury under the University of Arizona Health Sciences case.
Let me understand one more thing. And you have said a couple of times what your client was defrauded out of is the opportunity to win with random numbers, right?
He was deprived under the application of a lost chance doctrine.
Okay. But he was given 6 valid numbers
He was
on
given
that ticket that had been purchased the day before. So there's no dispute that you're not alleging these numbers weren't valid for the drawing, right?
correct.
Okay. And you're not alleging that the numbers aren't numbers that he would have specifically picked, because he was not trying to specifically pick numbers. He was asking for random numbers.
Correct.
So how then was he deprived of the chance? Because he received a chance through those 6 numbers. They were random as to him, because he hadn't said, I want 1, 2, 3, 4, 5, 6. He got just 6 numbers that someone else happened to pick.
Well, and I don't mean to belittle your hypothetical
Oh, please,
or the
belittle away.
circumstances. No,
I
really
don't have any
But
sense of ownership.
I want to buy a Jaguar, and they give me a Volkswagen. Well, you got transportation with 4 wheels. It's the same thing.
But that's not what you were buying.
Exactly, and that's not what he was buying.
You wanted a Jaguar, you got a Volkswagen. We can compute the difference in the value between a Volkswagen and a Jaguar. He wanted 10 chances at winning the jackpot. He apparently lost some of those chances to the extent that there's a fraud. Is the value of the chances he lost.
I suggest to you, Judge, that what he purchased was not his chances. What he purchased, or actually was given, unbeknownst to him, was the chances of someone else.
Mr. Ray, can I flip the scenario just a bit? Let's say that at that same Circle K your client walked into, at the time he walked in, there was a ticket on the counter for the 4 chances that he was ultimately sold for that night's lottery, or whatever lottery it was. And the policy of Circle K was to sell that to the next person that was willing to take it. Just add that into the equation, okay?
Right.
And as it turns out, they didn't give that unsold ticket that was sitting on the counter, they didn't sell that to him. Instead, they ran a random set of numbers and gave it to him, and he later found out that the ticket that was on the counter won. Would he have the same argument?
No.
That under the policy of Circle K, he should have been provided the ticket that was there, and that ticket became the winning ticket based on the time he was in the Circle K? And if not, what's the difference?
Because he is not a party to the policy. He is not a party. He is coming in asking for a specific selection of numbers and ticket.
And I was trying to give your client the benefit of the doubt on that one and say they actually had a policy where they should have sold it to him, but they didn't.
He would have, in my view, maybe my opinion's wrong, but I don't think he would have standing to enforce a policy of which he is not a party, he's not an employee, he has nothing to do with that.
Mr. Ray, you just said something that keeps sticking in my brain.
Okay.
You said he asked for specific numbers, but he didn't.
No, he did not, and if I misled you, I apologize.
He asked for random numbers, and he got numbers that were random as to him.
No, they were not random numbers, though. He got numbers.
But you
There's
said
a
earlier in response to Judge Jones' questions, you have no way of knowing what numbers. It could have been the numbers. These numbers could have been the ones randomly generated.
And he could have, had he gotten what he bargained for, gotten the winning numbers.
But these could have been the winning numbers. And also,
And-
it's theoretically possible Matter of fact, just as likely as him winning, that if he had asked for, no, I don't want that ticket, generate a new 6 numbers, they could have been the exact same 6 numbers that he got.
Well, I suppose that's possible. Of course, if you examine the ticket itself as a part of the record in this case, one would think that that was not be the case. What you had was a series
Random means random, so it could have been
but
1, 2,
what
3,
you
4,
have
5,
is a series
6.
of 5 numbers, and then the 6th number is in seriatim, 6, 7, 8, 9. Same beginning numbers, and the last numbers are the only ones that's different, and they started.
Are you alleging that that changed his odds of winning in some way?
I'm not suggesting anything in terms of, I think that the odds of winning aspect of this case is not within the purview of the review that is required under Rule 12b-6.
But in order for him to be defrauded, at least what I keep going back to, is there had to have been something that took away what would have otherwise been his opportunity. And there was no difference in opportunity that I can see.
Well, it is a difference in opportunity to him if he did not get that which he bargained for. And as a result of that, he loses the chance that he bargained for. He got somebody else's chances in a ticket in which was tendered to him based upon wrongful conduct, is our assertion, because it was sort of a bait and switch. Here, take this.
You've only got about 30 seconds left.
I do, so I'll reserve what little I can argue in 30 seconds. Thank you.
Ms. Dwyer?
Thank you, Your Honor. Teresa Dwyer of Fenimore Craig for Sir Dwyer.
Thank you.
Of Fenimore Craig, here with my partner, John Velitis, on behalf of Circle K. So I'll cut to the chase. It is appropriate to dismiss under 12b-6 if your damages alleged are speculative. We have cited you case law in the brief on 12b-6 motions that allows for that. And as the court has demonstrated through some of the questioning here, the damages here are in fact speculative. There was no actual injury here. The plaintiff asked for a certain number of chances where he did not pick the numbers. That's what he was asking for. And that is exactly what he received. The same amount of chances he asked for where he did not select those numbers.
Ma'am, there's no question but what that ticket played in, I assume, a subsequent lottery. Do you know what I mean by that? That night or the next night or whatever. Those numbers were valid. They were in play for the next time that there was a drawing in that contest.
It was valid for the drawing he was interested in, correct?
So is it fair to say, as I was sitting here, after Mr. Ray sat down, I'm sitting here, is it fair to say that when a person buys a lottery ticket or a set of lottery numbers that qualify them to be in play, they're purchasing one of two things, a right to win or, even greater likelihood, the right to lose?
That is correct. I think the case law, we've tried to find you gaming cases that make it clear that in the contract that arises, like the gaming contract context, what they're buying is an opportunity to play. They are not buying the right to win. There is no right to win here. It is just simply an opportunity to play against tremendous odds. I think the Brown case out of California discusses that at length. No right, an opportunity to play, which is what he had. If there's any...
Your client has an obligation. If someone walks in and says, I want numbers 1, 2, 3, 4, 5, 6, your client can't just give them different numbers.
If my client gives them different numbers, that is a different case from this. But the rules make very clear, the regulations that govern the lottery make clear that it is the purchaser's obligation to check the numbers, because we know how things work in the real world in terms of a store where people are running through and doing that. The clerks probably don't know.
What's your authority for saying that the lottery regulations issued by the Lottery Commission overrule the general duties in statutory and common law fraud representations? Because it seems to me, I don't care what the Lottery Commission has said. If I come in and say, give me 5 lottery tickets, and they hand me a ticket that's not valid, for example, that's a fraud, whether it's the Lottery Commission has said that's okay or not. So
Well, we're assuming a fraud where there may be a clerical error. Let's start with that. But why do the rules and regulations govern here? Because this is an exception to the gambling prohibition. It was adopted by statute, and the commission was authorized by law to pass rules and regulations to govern this. If those rules do not apply, and they are the only things that create the duties that arise under this contract, then you may not have a lottery. If, for example, you're exposing everyone, including the lottery and the retailers, to that much liability here. And the cases we've cited you on gaming, and some of them involving lotteries, do say that this is a unique type of contract that isn't normally allowed. It would not exist but for the law that created it, as an exception to the criminal laws. So it's governed very strictly by those rules and regulations and the statutes that govern it. So the rules here say, look, it is your obligation as the ticket purchaser to check that ticket and to make sure it is what you asked for. And I don't know that we have a fraud in this case the way it's been alleged. He alleges only that there was silence, that he wasn't told. But as the court pointed out, he could have checked the ticket. In fact, when he did check the ticket, he knew it was on a different date. The date is on the face. Quick Pick tickets also have a QP. It's on the lottery website as well, right next to the number. So it's visually easy to discern from the face of the ticket here.
Wouldn't the better course of action for Circle K and every retailer be to say, hey, I've got these extra ones I haven't bought. Do you want these?
It may be one way of handling the issue, but it may not be practical in all circumstances. And certainly the way the lottery is constructed, they're not obligated to do that. They don't want to create representations to people. They're allowed to resell tickets, and I can see a clerk sitting there going, okay, he's asked for, he's not going to pick any numbers, so I can resell this ticket. And the rules make very clear that if he checks the ticket, there's no argument. The rules were designed by their notice of proposed rulemaking to settle these kinds of disputes. He can turn it right back in, timely, and get a new one back, and he didn't do that.
You're saying that even if they had not represented him, this had been come off the machine the prior day, if he looked at it and said, no, wait a minute, this isn't going to work for me, he could hand it back to him and get a new ticket?
He can reject the ticket and get a replacement ticket. The rules make that very clear. And let me see if I can.
What's the site for that?
The rule in question say rules 19-3, 410, A through C. And that is if a dispute arises between the lottery and the claimant, he gets a replacement equivalent ticket. So if he's looking timely at the ticket and he comes back before the deadline, he can get a replacement. I would submit to the court if he comes back and complains, he's probably going to get a replacement ticket for the next lottery if he comes back late, because the store isn't going to argue with them about that kind of thing. So there's a remedy, which one of the judges talked to about what is the actual damage, if there is any there, and we don't concede there is any actual damage here. But if he didn't get the value of the ticket, the replacement value of the ticket is what he gets, not the pot.
I'm sorry.
I'm sorry.
So your argument would be that the maximum amount of damage he might be able to assert would be $4?
Correct. That is the opportunity. Or
His card, though, from them was...
You got 1-4 that was right, and then the second one, 6 that was wrong.
On the Quick Pick, he got one ticket with 2 chances on it, $2 a piece. That was the $4 ticket. And on the other ticket, he got 3 chances, $2 a piece. That was the $6 ticket. So he's really only complaining about 3 chances that he lost here, that he claims he lost. He didn't lose any chance. He got random numbers for that lottery, and there would be no difference. It's in odds-wise, there would be no difference in his opportunity, whether he actually picks the numbers. They've even stated that in the lottery. We know statistically, even if you pick your own numbers, there's no difference in chance in numbers randomly generated. But in this case, these were random numbers to him.
Well, and if you had your own numbers, if you had your own numbers that you bought tickets off of regularly, I'm not using the right lingo, sorry about that, but at least you would know if those numbers actually won. You'd be able to say, these are the numbers I requested, they are the numbers that won, but I didn't get a ticket that reflected those. Now, that would be a calculable damage, correct?
That might be easier to calculate. That's correct. You'd be able to tell, but we have had cases where we cited where people thought they had the winning ticket, had maybe winning numbers, and still they did not, the court found, no, that's still too speculative. So I don't want to go overboard. But yes, it would be clearer that he had actually asked for those numbers and he didn't get those, and we'd know if those numbers had come up.
So the value of the opportunity to play, because what the person gets upon buying a ticket is $2.
$2 for the ticket. That's a replacement cost of the ticket if you're assuming that's damage. And that's consistent with the regulations and the rules here. I would say the damages are still too speculative in any case, that the cases tell you all sorts of public policy reasons as well as legal reasons for why they don't entertain these as damages, even in the 12B6 setting.
How do you respond to Mr. Ray's argument that in the 12B6 context, at least, setting aside maybe summary judgment is a different issue, but in the 12B6 context, even if the damages are somewhere between 0.0001 cent and $250 million, that's a jury question, or at least a question that should survive, not be resolved on 12B6.
We disagree, obviously, and the cases indicate that it's not a jury question. It is too remote. There are some damages that are just too remote and too speculative.
And can be resolved on 12B6 as opposed
and
to
can be
summary
resolved on
judgment.
12B6. Can you imagine?
Give me
There
your
are
best case for that.
I think Brown out of California. I think Driscoll out of New Jersey. There's the Hochberg case out of New York. That was a racehorse case, but similar. And there was a Michigan case that I'm missing the name of.
Any Arizona authority?
No, we looked for Arizona authority, although we gave you Arizona authority that characterized, old Arizona authority that characterized this as gaming, a gaming contract. Most of those were criminal cases, I recall, at that time because there was no lottery allowed at that juncture. But Brown walks through the public policy reasons. You could not have a lottery here if you impose this kind of liability, and it is surely speculative to say whether he would have won in these sort of infinitesimal odds. And how do you ever really prove that? I mean, Brown talks about the fraud that occurs. I think it is Brown, the California case, that asks the question, if those numbers he had gotten on the ticket that he's complaining about today had hit the lottery, would we be here? No, people will.
You're back to my situation where I said if they didn't sell him the ticket on the counter and the ticket on the counter turned out to be the winning ticket, would he then have a claim that they should have sold that ticket to him? Same difference?
No, I think you're not. I don't think the lottery and the rules and the statutes that govern intend you to. You can go up and ask for a specific number ticket and you're entitled to that. But when you're talking about randomly generated numbers, there's no difference. And I don't know if.
So give me your situation again, because I thought those were synonymous. You just said he would have been in here claiming if
his numbers had hit, then those random numbers would have been satisfied, and that's
been given, as opposed to the ones that were generated for him that day.
He was given what he should be given all along, and the opportunity to possibly win. And he got that opportunity to possibly win, not to win, but to possibly win. And he got it with what he asked for, random numbers he did not choose. The argument about would he be here, I'm paraphrasing Brown, I think, has to do with the policy arguments for why you don't impose this kind of liability and why the damages are so concerning, because how do you really prove them when people will say what they will say when faced with a certain scenario? And it was paraphrasing Brown, I think, when I was saying, what would they say if they had actually hit? Can you imagine courts facing those scenarios? And let's be clear, this is probably just a clerical error of some sort, I would think. Or what do you do when the clerk thinks it's okay to give that these are randomly generated? And you have that happen in different locations at different types of clerical errors at different times.
But I was led to understand that the outlets are allowed to sell tickets that are not purchased for one reason or another, that are valid tickets. Is that not the case?
That is the case.
Okay. So, and I believe it was in the context of anything they don't subsequently sell, then the outlet has to pay for.
Yes, it does.
Okay. So that day there were two options. Circle K could have sat on that ticket, paid the, whatever it is, $4, $6, whatever it was that the ticket itself cost, or they could have sold it to a subsequent buyer. And if they had said, no, I want something that's just been run off fresh, then they would have taken that ticket back,
Correct.
sold a new ticket.
Correct. That is the way the gaming compact is, per the regulations. And again, one of the cases, I want to say it's the New Jersey case, says the regulations are the contract.
Who is the contract here between?
Well, that's been an interesting source of discussion with the courts that we've cited to you that deal with gaming issues. I think while the courts apply contract law somewhat and say this arises out of a contract, oftentimes, and I think in Brown and Driscoll specifically, they talk about the fact that the contract is really between the players themselves. It's really a pool of players. What you're doing is you're entering into a pool and you're all agreeing to play.
Is that your position then, that this is not really a contract between your client and Mr. Conway?
I think that, yes, I do not think this is necessarily a contract. I think it is based on a contract.
Well, then why wouldn't we want to reverse the Superior Court's awarding of fees to your client?
Because I think it arises out of a contract. I think the contract is...
Define the contract for
The
us.
contract is you ask for an opportunity to play.
Ask whom for a contract?
You ask from the lottery.
Is the
and
contract with Circle K or is it with the lottery?
They're one and the same. The statute says this lottery doesn't sell the tickets directly itself. The lottery is the agent per the statute. I think I'm looking at Section 5-5513, 5-562A, where we act as the lottery's agent. So in that sense, I suppose...
But when you said you weren't a party to the contract before, you were inaccurate?
I'm inaccurate, I guess. If we're going to say that the contract, I think there are a number of answers. The contract is directly with the lottery, but it is also amongst the players, and that is what the case law seems to indicate. For example, there has been...
Well, so the contract then is with the people who buy the tickets and the lottery. So it's not strictly between the purchaser and the lottery. It's between the purchaser, the lottery, and every other purchaser of an opportunity.
But we are obligated as the agent, as the licensed agent of the lottery, to sell those tickets. And we've cited you arising out of contract cases where you don't have to be a party to the contract, or the contract doesn't have to exist as to between you, but you're brought in because fundamental to the claims are, in fact, that contract. And those are also cited in our brief as well. There's one, for example, declaratory judgment action brought by an insurer, but he makes the defendants also not only the insured, but another individual, okay, that they were trying to figure out the relationship of what had happened. There's the Schwab case where the contract was with the general contractor, with the subcontractor, but they sued the general contractor over the fact that they got stiffed on, and they sued for an unjust enrichment case. So you have cases that arise out of the contract where, but for the existence of this gaming contract, these claims would not be brought. And I think that is why it's appropriate, and the trial court appropriately awarded us damages under 12-341.
Not damages, fees.
Fees, I'm sorry. We are, in fact, the agent of the contractor here, I guess, the state and the people who participate there in the gaming process. If you have nothing further, I'll sit down.
Thank you, counsel. And counsel, we'll go ahead and give you a full minute if that helps.
We're generous souls. Extra 30
29 and 152, do I get both? Just playing. The point of it is this. I encourage the court to focus on the standards that apply in a 12b6 context as set forth by the courts in Cullen and specifically Justice Bales in the Coleman case. You assume the truth of all the material allegations that are alleged. If they state a cause of action, you cannot grant a motion to dismiss. On the speculative aspect of damages, I miscited, and I want to correct my misstatement earlier. I cited University Health Sciences Center, and then I read a passage, and that passage was actually from Felder versus Physiotherapy Associates. And that's on page 6 of the reply brief. The point of it is in the Felder case, they're saying that this is a jury issue. And this needs to be argued and litigated to a jury on what the damages actually are. The Felder case says we put great faith and trust in juries to decide what the damages are. The question before the court under 12b6 context, looking at the complaint, is, has a complaint been stated that is subject to proof? We have proof in this case, but that is not an issue that we're not to be litigating that issue with this court. I mean, if you want to know, do we have video? Yes, we have video. Do we know the facts and circumstances of how it happened? Yes, we do. And we tried to outline that both in the complaint with some detail, as well as in the factual recitation in the briefs. Lastly, with respect to the contract aspects of this, the complaint did not allege a contract against Circle K or the lottery or the general pool of people, which the opponent is suggesting that this contract exists with. There was no contract breach alleged against the lottery because the lottery did not do anything wrong. What happened is that apparently their agent, Circle K, passed a ticket that was not random numbers, as I heard asserted, but rather numbers that were specifically selected by another individual on a completely different date and passed without the consent, permission, or even request for permission by Mr. Conway.
Thank you, counsel.
Thank you, and I appreciate your
appreciate
Judge.
your argument. We'll take this matter under advisement and issue an decision in due course. We appreciate the briefing and the argument today. If counsel in the next case are present, we will stand in recess while the next case comes up on counsel for Lawrence versus Roar. Are they here? Thank you.
Judge, may I interrupt for a point of order?
Yeah.
You had indicated earlier in your question that you wanted a supplemental brief or at least the submission of that next case.
As supplemental citation.
All right, I will.
No briefing.
Thank you, Judge.
Thank you, counsel.